Hearsay exceptions. Let's talk about them. Hi, my name is Carl Birkhead. I'm an attorney with Wirth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for almost 8 years now, and I want to talk to you a little bit about hearsay, and more specifically, when that rule doesn't apply. So, I've talked about this before. Hearsay is essentially an out-of-court statement made by a declarant outside of court. So, um, basically, if you happen to come upon a car accident and you start helping out, help with the victims, help with the damage, whatever, you become a witness in that case, you might be asked to testify about the circumstances surrounding that accident, and anything that was said by anyone at that scene is technically hearsay. But even though it's an out of court statement made out of court, being offered for its truth, in this instance, there's an exception that would work. This basically, it's if you're describing an event or condition that at the time of the accident. So let's say you get to the accident and you hear someone screaming, "Oh my God, there's blood everywhere." And then you're on stand and someone's asking you, "Well, can you describe it?" And you say, "Well, I know that there was blood everywhere." How do you know? Well, someone was saying that. It's a condition, or it's a statement made about that condition in the moment, explaining the surroundings. That's okay. It's an exception. It falls outside of the exclusionary rule. You can still get that in. Similarly, if someone made like an excited utterance, saying, you know, "Oh my God, that was crazy," or "Holy crap, I almost killed you," something like that. Especially if that person actually was the one that caused the accident, or if the case that you're testifying about is whether or not that accident was caused by the person. You can say, "Well, I heard him say, 'Oh my God, I almost killed you.'" That's an excited utterance. It's also a defendant's statement against interest, which is another hearsay exception. So that's 3 in 1 right right there. Um, but things like that, if it was something that's just describing the condition, or something that was just a spontaneous excited utterance, or if it's something that the defendant just says that's against their own interest, all of those are hearsay exceptions that can still get around that rule. There's some others. I'll talk about those a different time. But if you have questions about this, definitely give me a call. My name is Carl Birkhead. I'm with Wirth Law Office, and I want to help you make law easy. Thank you.